Is your memory and patience running low? Perhaps it's time to unlearn a few things. Hi, and welcome to The Law Simplified. I'm Shaveen Bandarnayaka. A commonality between students from all around the world, be it those who have just started their LLB or GDL program, about to graduate and is in their third or final year of university or a respective institution, or for that matter, even those who are professionals, who are lawyers, barristers, and solicitors, aiming to progress their academic career by virtue of an LLM or a PhD, is the fact that law is vast and the volume of content on most occasions is overwhelming. On a number of occasions on this very YouTube channel, as well as the different platforms The Law Simplified is disseminated on, I've tried to impress upon all of my fast track, masterclass, as well as those of you who watch these YouTube videos to not just take in the volume of content and read as much as you can, but to read smarter than usual. Oftentimes, this might be easier said than done. And what I have gathered when I speak to my students on a one-on-one basis is that the most difficult part for a student to recognize is what to keep and what to let go. I have often said that the most important skill as a law student and a legal professional at that is to be able to extract that which is important, absorb it where necessary, and jettison excess. What do I mean by this? As much as it might be theoretical for me to say it in this manner, I thought it might be much easier to put it into practice. Let me show you by looking at an extract from a textbook that you might be presented with in your university or academic career, and what I would expect from a student who is not just reading smarter, but analyzing circumstances to do. Let's have a look. For this example, let's have a look at the definition of an offer as described by Ewan McKendrick in his book Contract Law. An offer is a statement by one party of a willingness to enter into a contract on stated terms, provided that these terms are in turn accepted by the party or parties to whom the offer is addressed. There is generally no requirement that the offer be made in any particular form. It may be made orally, in writing, or conduct. Now, there's a lot of information to be had here. On the one hand, to help you understand what an offer is, and at a more deeper level, and arguably from an examination standpoint and from what an examiner would expect and an employer for that matter would expect later on, the analytical aspect of your thinking that should be extracted from it. So the first thing that we should do is try and extract the most important or relevant information from this so as to be able to summarize later on when we prepare our notes, if you're in your university or you're preparing your revision notes for examination, or if you're reading material from a textbook in order to prepare submissions in court. Now, once we take this overall component of what an offer is according to McKendrick, a few things should stand out. Essentially, what he's trying to get at in this paragraph is to say that an offer is a statement of willingness to enter into a contract on stated terms, and that offers can be made with no specific form. There are a few things that we can gather from this which we will look at, but notice how the entire extract can then be distilled into the most important bits. Notice not really what I have left Notice not what I have extracted, but what I have left out. It's very important to not dilute what we are learning with elements that may be covered later on in terms of the chapter or later parts of the book. Now, in this particular overall extract, McKendrick tries to explain that not only is an offer a statement by one party of the willingness to enter into a contract, but that subsequently, provided that these terms or whatever the stated terms are accepted by the other party, this may move on to become an agreement. At this stage, in order for us to understand what an offer is, the elements of acceptance is redundant. That would generally and most definitely in this book of McKendrick be covered later on. So rather than overwhelming yourself with information that you might not need at this stage, extract that which is most important to understand one particular topic at a time. Most law students tend to fail primarily because they try to memorize rather than theorize. Theorizing is the process of extracting the most important bits and retaining an understanding of it, as opposed to verbatim knowing each individual word or phrase or paragraph that the writer had tried to impress upon the other. Now that we have taken the most relevant bits, namely the fact that the offer is a statement of willingness to enter into a contract on stated terms and that it can happen in any form, the next stage then is to try and articulate what this really means analytically. How exactly do we use it? Now, from an examination standpoint, to me, this suggests two things. On the one hand, that any statement that has stated terms and is addressed to another person can be an offer. So, statements need not essentially be in writing for that matter. It could be either oral or by conduct. Now, rather than saying all of that in the extract itself, or rather than trying to retain every single bit of it, it's important to understand that you must take out the framework. Understanding a particular concept is far much better. Understanding a particular concept is better than trying to memorize bits and pieces of it. It's like when you prepare to give a speech, for instance, in public. It's much better to know the key points or the cliff notes, so to speak, of what you're going to communicate and then talk about it. It's like, for instance, if you're trying to give a speech in public, it's better to have cliff notes or short summaries of what exactly you want to talk about and then go on a natural context of speech rather than memorizing each individual word. The effect of that is, in the event you forget one or two words, your entire stream of thought is lost and you won't be able to finish your speech at all. The same is true when you actually try to prepare and study for law. It's not really about the words that are there on paper, but what you are able to gather and understand from it. Once you are able to do that, it's much simpler to take a 300, 400 or even 500 page book, skim through it to the level that it's an intellectual skimming. What I mean by that is you read to understand rather than reading to remember. Right. Now this extract was meant to achieve two goals. One, to showcase a method by which you can manage your time in terms of preparing and studying for any examination in your respective university or institution. On the other hand, it's how not to get overwhelmed by the bulk of content and the material available. Oftentimes, when you look at a textbook or when you look at any other source of material that's provided to you, chances are there would be at best 25 to 45% of that information that's relevant to you. Now, I do realize that there are material that's academic books and resources out there which are heavily concentrated, and I don't consider those into this category. Rather, I prefer to look at the essential reading that is prescribed by your universities that often go on to 200, 300 or 400 pages or even more. The idea or the goal of a good student and a legal professional at that is to be able to calmly assess the information that's been provided, break it down into digestible chunks, absorb it when necessary, and jettison any excess. Time management is as important as being able to understand the law. Overall though, apart from the textbooks and the written material that's provided to you by your university, if you feel the entire process of it, everything from the lectures to the tutorials is in excess or overwhelming, I'd highly recommend having a look at the comprehensive online law school platform. It's complete with comprehensive theory, tutorial, and workshop lessons that will not just help you understand the law, but also on how to break down examination questions and answer them in a manner that would not just help you pass, but ace your examinations. That being said, until the next time that we meet, have fun, stay safe, and as always, obey the law.